This is still Good Morning Nigeria on the network service of the NTA, and to launch our discussion on 6 years of Buhari administration with focus on the judiciary, let's join Ekene and Jule for the background report.
Judiciary is believed to be the foundation upon which democracy grows and develops because it is the only organ that deals with the administration and dispensation of justice in any democratic nation. This is why for both the proverbial common and uncommon man, the court is like a holy sanctuary. For this organ of government to effectively perform its constitutional duties, it has to be seen as impartial and independent from executive arm of government and any other undue influence. Unfortunately, this has not been the case for several decades in the country, as cases abound on corruption within the judiciary, denial and delay of justice, as well as interference by the executive arm of government. The emergence of President Muhammadu Buhari in 2015 came with a clear message of building a strong judiciary, properly armed to fight corruption in Nigeria. 6 years down the line, the president has made several efforts at strengthening the judiciary arm of government, some of which include signing of the Administration of Criminal Justice Act in 2015 and the Correctional Services Act 2019 into law. These laws are intended to provide a comprehensive legal and institutional framework to tackle delays in the dispensation of justice, prison congestion, awaiting trial inmates, and non-custodial measures. However, it is not yet uhuru for the judiciary, as delay in justice dispensation has continued to persist, while demands for full financial autonomy for the judiciary have continued to dominate discussions. The ongoing strike by members of the Judiciary Staff Union of Nigeria, which started since 6th of April, has led to shutdown of court services for about 8 weeks now. As we mark 6 years in office of the present administration, questions that readily come to mind are: to what extent has the criminal justice system been enhanced in the last 6 years? What impact has the judiciary made in advancing Nigeria's democracy? Guests on Good Morning Nigeria will be giving their perspectives in a moment.
Thank you very much, Ernest Ndulue, for that background. With us in the studios now to discuss this issue, we would like to welcome the Honorable Minister of Justice and Attorney General of the Federation, Abubakar Malami, learned Senior Advocate of Nigeria. Pleasure to have you on Good Morning Nigeria again.
Thank you, Kingsley.
Okay. Also here with us in the studios, another Senior Advocate of Nigeria, who is President of the Center for Social Legal Studies, Professor Yemi Akinseye George. Delight to have you this morning.
Thank you very much.
Okay. All right, so let's begin the focus of our conversation this morning, first with the Honorable Minister of Justice and Attorney General of the Federation. 6 years on, incidentally, you've also been with the administration since 2015. What are the milestones in the judicial services sector, of which, of course, you are the Chief Law Officer of the Federation?
Well, the milestones, as far as the Judicial Justice Administration is concerned, even the polity is indeed an encouraging one. But you cannot appreciate the success story associated with it without looking back, perhaps to the period in the 1980s down to early 90s, and juxtaposing same with what obtains in recent times as far as the justice sector reforms are concerned. You may very well recall that judiciary as a system was in the 80s or early 90s used much more as an instrument of a kind of undermining the democratic process. How do I mean? Take into consideration a situation whereby the whole lot of electoral and democratic process was annulled at a point by the judiciary. You can also factor comparatively the speed at which judicial processes were being administered in the 80s down to the early 90s as against what obtains now, for you to fully appreciate what progress, what developments, and what encouraging milestones have been recorded with the advent of the administration of President Muhammadu Buhari. Now, fundamentally, looking at the judiciary and general justice sector reforms, one thing you cannot take out or take away as a major milestone as far as the administration of President Muhammadu Buhari is concerned is the enhancement of judicial system from two fundamental fronts. One is legislative framework that now more or less support the advancement of democratic process. And to that extent, we are living witnesses to what constitutional amendments, what statutory amendments are put in place to deepen the democratic process by the judiciary. For example, when it comes to justice sector administration, we are living witnesses to the quality of decisions that are now being handed down by the judiciary. And in effect, the judiciary has effectively keyed into the sustenance of our democratic culture. Today, cases are not only being taken, but they are being speedily disposed. Before the advent of the administration of President Muhammadu Buhari, we were living witnesses to free election matters being delayed in judicial system for over 10 years. I am talking of free election matters. And the same thing with election matters being taken for over 10 years. But then arising therefrom, there are certain statutory amendments effected to the electoral process to ensure the ceiling as far as the timeous and timely determination of cases are carried out within record time. And in terms of speed, we equally have taken a kind of consideration of the two, both civil and criminal determination of cases in record time. So within the context of the judiciary factoring and keying into the sustenance of democratic culture, within the context of the speed, within the context of the having in place a system that forces the political elites to submission to the judicial and democratic culture, I think the government of President Muhammadu Buhari has done wonderfully well by way of bringing a culture that makes judiciary a stakeholder in the process of building a sustainable democratic culture, a stakeholder in the speedy determination of cases, and indeed a stakeholder by which the political elites are forced to submission by way of submitting to the judicial process in the sustenance of democratic culture.
Okay, thank you so much, Abubakar Malami-san. Let me come now to Professor Yemi. He has 6 years of the Buhari administration, judiciary in focus. He has really had some achievement in judiciary. Would you say all this has sort of impacted in the lives of the ordinary Nigerian?
The impact of the judiciary on the lives of the ordinary Nigerian, to my mind, is not quite visible. To my mind, those who have benefited more from the judiciary appears to be the political class. The cases that are determined with speed are the political cases. The cases that affect the business, that affect poor people, those cases don't get speedily determined. So we need improved motivation, for the judiciary, so that they will be able to provide greater succor for the greater majority of the public, and but it's not all negative. Just as the Attorney General has said, there are areas where we have noticed progress. For example, appointment of judges. This administration has been fairly transparent, in terms of allowing the judiciary to handle appointment of judges and not interfering in that respect, letting seniority prevail in that process. Because it is important that the independence of the judiciary must be preserved, to a large extent. That has been recognized. Another area is in the area of high-profile corruption cases, just as the learned Attorney General has pointed out. Before 2015, high-profile corruption cases were never resolved. They went to court and got stuck. But since 2015, we've had high-profile cases concluded. Even though there appears to be a decline again, the Supreme Court has upheld the provision of Section 306 of the Administration of Criminal Justice Act, and that has enabled the judiciary to conclude important high-profile cases, and that has sent a signal to the political class that it's not going to be business as usual. You can no longer keep your case in court forever through all kinds of statics and applications. So that's a positive for the judiciary, and and I'm also aware of the Executive Order 10, which the administration has also issued, which the President has signed, which the governors appear not to be
too happy,
willing to implement. But now, perhaps because of the strike and all the the ongoing pressure from the public and civil society, because for me that's going to be one of the biggest legacies of the administration if they can successfully establish and institutionalize the autonomy, financial autonomy of the judiciary. For me, that's going to be a major contribution to the sustainability and consolidation of democracy.
All right, thank you very much, Professor Akinsanya George. We'll return to you. Let's return to the Attorney General of the Federation. Just one of the points that Prof made. We have seen in 6 years of the Buhari administration a recourse to the use of executive orders. Why?
Well, perhaps the major reason for having recourse to executive orders is to consolidate and complement on the efficiency of the system. When you have in place a legislation, it is only natural that that legislation, life must be put to it. And how do you give effect? By way of having life to the operation, application, and enforcement of a legislation. Executive orders comes handy. Now, take for example, Executive Order number 10 that has just been cited by my learned brother Silk Akinsanya George. We have in place a constitutional provision, Section 121 subsection 3, particularly of the Constitution, that is put in place. And the essence and spirit of the section is to complement the position of the government with particular regard to the financial autonomy and independence of the judiciary and legislature. You have the instrument, you have the constitutional provision, but giving effect to it is becoming an issue. But the responsibility for the implementation, as you rightly know, is indeed a collective responsibility of government in cooperating and expecting perhaps support, enforcement, and application by the executive, the judiciary, and legislature. So how do you now give effect to the constitutional provision, taking into consideration the collective responsibility and obligation of the government and governmental organs? That is how and where the executive order comes handy. It is about supporting an existing legislation to ensure at the end of the day that the execution of a collective mandate has been consummated and carried out. Now, with that in mind, the Executive Order number 10, with the constitutional provision of the independence and the state judiciary and legislature, it becomes a responsibility and obligation on the part of the executive judiciary and indeed the legislature to do what? To provide the support to the implementation of the constitutional spirit. And that is what makes executive order handy on the part of the executive to ensure, to put in place a mechanism that will now bring about the existing organs of government towards the implementation of a constitutional mandate, for example. So executive orders perhaps are new innovations in the Nigerian political systems that sees to the enforcement, application, and operation of a statutory responsibility, so that at the end of the day, we do not end up having in our statutes, having in our constitution, provisions that are not eventually implementable on account of the fact that coordinated approach through executive orders are not put in place.
I want to ask you this question because it's been fairly common in the 6 years of the Buhari administration, although we seem to have heard less of it last year, perhaps because of the pandemic. One of the issues arising from the relationship between the legislative branch, in this case the National Assembly, and the executive branch had to do with Mr. President declining assent to some bills that were presented to him. And usually in his response, by way of reply to those bills, errors were spotted in the bills, so that there were clerical errors or cross-referencing errors and all kinds of things. And one of the presidential aides, who was also a lawyer, had indicated that the president has a refinery, as it were, for processing bills that come. And I would imagine that you are at the center of that refinery. Why has it been such a challenge, as it were, to perhaps have backroom channels for dealing with some of these pieces of legislation? Because sometimes when the piece of legislation gets returned to the National Assembly, it hardly ever comes back or is delayed.
Well, I think, you see, the democratic process, as far as the Nigerian state is concerned, is an evolving process. And when you talk of legislative bills, for example, it is only logical that there has to be a comprehensive analysis of a legislation to ensure, one, that there are no inherent, perhaps, conflicts with the Constitution. There are no inherent conflicts with existing legislations, and then taking into consideration the limited resources of the government, that the resources are available for implementation, perhaps where there are financial factors for consideration into it. But then, arriving from experience, we come to terms with the reality that bills takes a lot of time, resources, energy to come up with. And it is only logical that we should consider a possibility of minimizing the level of assent and bringing about consensus building between the executive and legislature in the lawmaking process. And that gave rise to an inter-organs, multifaceted approach, whereby we put in place a committee or interfacing committee between the executive and legislature, whereby those bills, before being finally processed at the National Assembly, are analyzed in line and in tune with the prevailing constitutional provisions, in line and in tune with the prevailing laws, in line and in tune with the prevailing policies of government and limitation of resources, among others. And what we are witnessing today are serious minimization of such impediments. Most of the bills that were presented for assent of the president this year had succeeded in being assented to. And we now factor added instruments of consideration, for example, corrigendum, when you talk of perhaps issues relating to cross-referencing and perhaps typos among others, rather than perhaps refusing assent on those grounds. The consideration is being made for corrigendum, which is allowed through the legislative process. And I think we have witnessed a great improvement in lawmaking process with particular regard to the function of the executive as it relates to assent. I think we have learned a lot of lessons that have proven to be beneficial and that have eventually translated to saving time, energy, and resources working between executive and in the legislature.
Indeed, the Executive Order 10 is still on the front burner in Nigeria. Some, experts are, saying it is timely. Some say it still has some grey areas to address. Maybe that is why state governments are not fully accepting the implementation. So where are we on that?
Well, for whatever it is, I think the executive order has succeeded in establishing a meeting point, in bringing parties to table, in building consensus within the context of the autonomy. Regardless of what is being said, what challenges we have in place, and what controversies have been generated by the executive order, the fact remains that all parties have come to terms with the reality of the situation, that autonomy of the state legislature and judiciary has been established constitutionally. And they have equally come to terms with the reality of the situation that there is need for a decisive action as far as for the implementation of such autonomy. I think what is unfolding, arising from the controversies generated both on the part of the judiciary and judicial workers, the judicial staff, and indeed on the part of the governors, it is about a roundtable understanding that is expected now, at the end of the day, to establish a common understanding as far as the modalities for the application, operation, and enforcement of that autonomy is concerned. And I think a lot of progress is being recorded in that direction. So the bottom line is there is no disagreement as far as the autonomy of the state legislature and judiciary is concerned, but then the modalities are what is being considered for the purpose of ensuring the implementation, enforcement, and application of that autonomy within the context of Order 10.
All right, thank you very much, Learned Attorney General. We have another guest who is joining us for this conversation from our Port Harcourt Network studios. He's a regular guest on Good Morning Nigeria. He's also a lawyer, Chief Festus Oguche from our Port Harcourt Network Center. Delight to have you with us on the program this morning.
Yes, thank you very much, Kingsley. Thank you a lot. A very exciting discussion so far.
All right, so maybe we'll give you the opportunity of making your first pitch right now. What's your assessment in general of the Justice Sector Administration, 6 years of the Buhari administration?
Well, the judiciary is the last hope of the common man, they say. And we all know we've been battling with challenges with that system for quite some time in terms of access to court, in terms also of the quality of justice, in terms of the level of public confidence in that system, and the level of response to the complaints from members of the public regarding that system. That was then. To a large extent, some of these problems have been taken care of. And I think in that regard, great commendation will be given to this government, because the idea of an independent and autonomous body, judicial body, being as imperative as it is, has not gotten down to us really in its real sense until now. You know, when we had the provisions like in section 121 of the Constitution, which the Honorable Attorney General very well alluded to, then the fact also that the judicial system has been bogged down with a lot of political interference from the elites. All these require some bit of reforms here and there. And those reforms are coming gradually. I'm quite excited by the fact that we now have in place Section 121, but it beats my imagination that the president has to invoke his powers under Section 5 of the Constitution to get the states to implement that particular provision. The idea of financial autonomy to the judiciary is very, very important, and because it should have some shade of exclusion from the machinations of the political elite, and that's the whole essence of Order 10, which the president put forward. But then we still have a strike action and industrial action being done by Judicial. And I'm beginning to wonder whether it takes a strike action to get the governors of the states to abide with the provisions of the Constitution, and also which provisions have been enforced or implemented by the Presidential Order 10. We also have a lot of things regarding the tradition of the judicial system in terms of seniority and appointments, which the federal government has been religiously following in the appointment of the Supreme Court, the Chief Justice of the Supreme Court, the Chief Justice of the President of the Court of Appeal, Chief Justice of the Court of Appeal, Chief Judge of the Court of Appeal rather. But at the state level, you see a haphazard arrangement that does not abide by these notions of seniority, which is part of the tradition of the legal profession. I think some of these things must be put into proper perspective. Then again, to some extent, I'll very much commend the administration also for being very mindful of its responsibility to ensure that there's less corruption on the bench, even though they started it in a quite erroneous fashion by getting some justices and judges arrested. The Court of Appeal has corrected that error though, but I think it's sorts on the proper perspective of understanding that judicial immunity does not extend to crimes committed by judges. It only hovers within the restrictions of the judicial office, of the judicial or the judicial responsibility of the officer in charge. There's also the issue of recruitment of judges, recruitment of judicial officers, which I think at that level the government has, the federal government particularly, has done much credit to, and we must ensure that these things are properly put on ground to make sure that the proper persons, credible persons of integrity with high practical and intellectual ability are made judges and are appointed to the bench.
Indeed, Professor Yemi, Senior Advocate of Nigeria, raised some issues and said judges' appointment has sort of increased, and federal government is not interfering with the appointment of judges in Nigeria. But the question is, do we have enough judges to try out cases and, give justice to millions of Nigerians who want to see that they get justice, and whatever it is they are following should come to the logical conclusion? Can it be fast enough?
Well, now we had some justices at the Supreme Court. The Constitution recommends 21 justices, including, if you include the Chief Justice, it becomes 22. But at the time we had about 13 of them, though the Constitution did not say if you have a number less than 21, it makes whatever decisions they make a nullity. But to the extent that I know, I think that those gaps have been filled sufficiently at the Supreme Court, that we have a full member of the justices. I may be wrong there, but I think that error has been corrected. The issue of appointment of judges and justices is quite there. Recently, a lot of them were elevated from the Court of Appeal to the Supreme Court, and some were also elevated from the Federal High Court to the Court of Appeal. In that circumstance, there will be need for more appointment of judges, and in these appointments, we should abide by the constitutional prescriptions as to number, because it's not just the number as per sitting of the judges, but also the more the number, the more the intellectual rigor that's involved in decision making. This is particularly so in this era of the law that has expanded to very hybrid areas, recondite areas, cyber law, money laundering law, and all that, cyber crime, and which requires some expertise, for dispensation of those such cases. So it is very, very important that the number of judges be filled up as much as possible. And once there's a vacancy, that vacancy must, as a matter of urgent attention, be filled up. To the best that I know, I think the government has been doing well in that regard specifically. I may have some reservations about the justice system, the administration of the justice system, but in these particular areas, specific areas, the autonomy, independence of the judges, the appointment of judges, the mode of appointment, I think I give kudos to the current government for that.
Thank you very much, Mr. Festus, Chief Festus Oguche. I'll return to you in the course of the conversation. Let's come back now to our Abuja studios. Professor Akinseye George, the rule of law is the linchpin of democracy. What is your assessment of the rule of law under the Buhari administration 6 years on? We know that there are many elements in the rule of law, which will include prosecution of cases, law enforcement, as it were, and obedience of court orders.
I would say that it has been a mixed bag. A mixed bag of the good and the bad, and perhaps the ugly as well. You know, when we talk about the rule of law, you know, we are talking about, you know, supremacy of the law in the real sense of the word. I have a challenge, you know, with the situation in which courts are expected to perform more functions, particularly because the administration has identified anti-corruption, which is a big challenge in the country. And the number one tool that you need to establish the rule of law in that respect are the courts. The courts, the prosecutors, the investigators. You know, to what extent have we strengthened these institutions of accountability, these institutions of the rule of law in these last 6 years? To what extent? You know, judges are still on the same salary. Judges have been on the same salary for more than 10 years, for some 15 years, depending on when you were appointed. So these are demotivating factors, you know, and our judges still write down proceedings in longhand. This can be killing. That's why cases are not moving smoothly. A few courts that have been digitalized, you know, I mean, our organization, for example, we had the opportunity with the support of development partners to digitalize about 2 courts, to give them recording equipment, video recording. The report we are getting is that those courts are moving faster because all the judges need to do is sit down and observe proceedings. If you like, you take notes. So, you know, much more can be done to strengthen the rule of law by strengthening the institutions of accountability. Look at police, for instance. Police is the prosecutors, the investigators. You know, many prosecutors have to go to court using their own salary, using their own funding. You know, there are I train prosecutors, I interact with them. But because they are government civil servants, many of them cannot talk. They cannot complain. Investigators, look, what I'm saying in effect is that to strengthen the rule of law, there must be greater investment by government in the institutions of accountability. The anti-corruption bodies, the prosecuting agencies, the courts. Salaries must be reviewed, particularly because we expect more from the judges. You go to a court now, you find court dockets. You find 15, in fact, 30 cases in some instances. Of course, there are areas where judges may not be busy. We need to reorganize the entire system, you know, which is why I salute what the Court of Appeal has done, whereby judges were brought from some areas where where cases are not too many to come and, you know, clear the docket in Lagos, clear the docket in Abuja and the busier locations, you know. So I think it has been a mixed bag. We need to do more to strengthen the institutions of accountability, to strengthen law enforcement, you know. And then, I mean, I'm looking at the challenge of law enforcement. Many of the things we use the army for, we should use police for them. We should use the police for them because army should come in when it is no longer possible. But now when you demystify the army, small law enforcement operations, we send police there. We send the army there. We send the military there. So I think we need to strengthen the institutions of accountability. You know, we need to get You know, I mean, the one positive that I like to talk about is the issue of community policing, which the administration has introduced through the Police Act. But what is the implementation? We need to feel the presence of government in every nook and cranny of the country. In other words, there has to be cooperation between the community and the police system. You know, for me, all this issue of setting up regional police and all of that, you know, the reason why it is because there's a huge vacuum from the national police. You know, but the national police should be assisted, should be encouraged, so that in every community, through cooperation with the, that's the whole essence of community policing. You know, so I think that with respect to the rule of law, we need to strengthen. I mean, we need to strengthen the institutions of accountability. We need to strengthen the courts. Yes. We need to strengthen the investigators. We need to strengthen the prosecutors, so that they can really go out to deliver on their mandates. Yes.
Talking about prosecution in other climes, prosecutors are powerful. Like in the US, in the UK, they are powerful people. What is the synergy, you think, between the judiciary and the police on investigative, research and prosecution? Do we have the tools to do that and make sure that somebody who commits a crime faces the full wrath of the law?
I'm not aware that we have done enough in that respect. A constitution cannot work itself. We've got to make the constitution to work. You know, people are talking about new constitution and all of that, restructuring and all of that. It is not the same human beings who will operate all these systems. The same human beings. So we need to look inward, look at our character, look at our values. You know, look at these institutions that we have put in place. Are they adequately resourced? Are the right people in the right places, first and foremost? Do we not need more people to encourage them, to assist them? And then, is there no way we can encourage even the private sector? Because the government has so many responsibilities. Can we not create even greater partnership, greater involvement, greater platform for the private sector to assist in law enforcement? You know, Security Trust Fund, for example. I don't think any businessman, any professional, any trader who is called upon, come and support law enforcement, you know, through a fund. People are willing to contribute, but they need leadership from the government. Government is literally overwhelmed. You know, so we need to rejig our institutions of accountability. That's why a few guys have gone to the forest and they're fighting the system. And they're getting more powerful because they're able to use force to extract resources from the system, which is not what it's supposed to be. So, I mean, the rule of law, all of us are protected by the rule of law. The elite, in fact, the elites have greater need for the rule of law. So the political elite in this country, those in government, those in opposition, need to come together and find a way by which we can rejig the system. Strengthen those who are there, the ones that are not performing their functions, take them out and bring in new elements. So many young graduates roaming the street who can be injected into the police, so that we reserve the military for the hardcore operations, terrorist fighting. But law enforcement in the communities and so on, we can use the opportunity. In fact, with the challenges we face now for Nigeria, for me, there are opportunities. But there must be commitment, there must be sincerity of purpose, and there must be leadership. And I assure you, Nigerians are willing to help. They're willing to work. But a situation where we let some hoodlums and individuals who do not have the good of the country in mind to start dictating the pace through abuse of force, you know, control of weapons and all of that, I think it's a great threat to the rule of law. And I do not want the legacy of this administration to be rubbished. This administration has achieved a lot with respect to look at the economic reform that is going on, look at the transport system, look at the administration of criminal justice that is being implemented through the speedy dispensation, recovery of assets. A lot has been achieved. But if we do not ensure that the rule of law becomes paramount, then people, you know, all kinds of warlords will take over the system, and we do not want a situation of anarchy in our hands.
Thank you. Let's return to Port Harcourt and bring in Chief Festus Oguche again before we get the Attorney General to respond to the submissions by the other two guests. Chief Festus Oguche, what's your assessment of the rule of law in the country? I mean, some persons will say that there's a great deal of lawlessness all over the place, but listening to the delivery of justice and the entire value chain. There has to be law enforcement, there has to be diligent prosecution, and then, of course, you have to have the sentences carried out. Are we doing enough, even as citizens, in assisting the rule of law?
Very much for that question. The rule of law entails the due process of the law. It also entails equality before the law, supremacy of the Constitution, and our general submission to the dictates of law. It's been quite a very long journey for us, as a matter of fact, in entrenching the proper dictates of the rule of law within our democratic ambience. And some begin to question the constitutionality of certain acts, not just by government alone, but also by the people, in terms of the adherence to these principles that are properly well enunciated. The rule of law does not operate in a vacuum. It deals with human beings, it deals with human situations, it deals with circumstances by which it can come into play, in terms of the extent to which law is upheld. The country, as it is now, is derailed very, very terribly. Not necessarily because our rules, our laws are insufficient, but for the simple fact that we have a lot of people who want or prefer to go the other way, which is very unhealthy. Some of these things could emanate by the fact that we don't have adequate provisions for prosecution of persons who have done one or two things, and also that probably we are reluctant, or those in authority are reluctant to give some people the hardcore benefits of going against the law. To that essence, I will start by saying that at the early years of this democratic experience in 1999, we had a lot of resurgence of militancy around here, and a lot of individuals were involved, but at the end of the day, there was an amnesty, and in spite of the amnesty, it started to grow from a small injury into a festering sore that we now have kidnapping all over the country, there's insurgency, there's all that. And we all know how Boko Haram started, but it's rather unfortunate that a lot of things have gone wrong in that sector, but a lot of people have not been found, have not even been taken to court, the court of competence, to have them prosecuted. There are lapses in those areas. Then, of course, some of the attributes of giving some persons more equality before the law than others, it makes the whole thing look like a ruse. The rule of law must exist principally to ensure that there's orderliness in society. And when it fails, then you're looking at anarchy. We are at the verge of that, but God forbid we will not get there. And I think it behoves on the government to rise up to that challenge, to make sure that these things are placed in their proper indices. The prof there talked about synergy between the prosecutor, the administrators, and the judiciary. I think the synergy is already there. It's simply that maybe we have not been able to develop to that level, to such level that we can begin to harness that synergy to the extent that it can be very much available to us. It's also important to emphasize that the courts have put in so much in ensuring the speedy adjudication of cases, particularly criminal cases, and some of the matters that are brought before them are not before the courts are not properly investigated. And at the end of the day, I think they usually will blame the courts, that the courts are responsible for the level of corruption and all that. But look at the cases, look at the investigations, and you see at the end of the day, the court will not manufacture evidence to say that this person is guilty, when actually there's no sufficient evidence that can inculpate him, in those charges. So these are the issues that come into play, and we know that there are a lot of technicalities involved in operating the rule of law, allowing it to operate in such manner that it will have full effect. But these are the areas that should pose challenge to the government to bridging the gap, coming to the real issues of play. Thank God the Attorney General of the Federation is there, and make sure that people who commit crime pay for their crimes.
All right, Chief Oguche, thank you very much. So we'll come back to our Abuja headquarters studios. Letting the Attorney General of the Federation, your response to the question of the assessment of our guests of the rule of law under the Buhari administration.
Well, rule of law as a concept is a very wide concept. It is a product, one, of legislation, two, of a judicial function, and three, of an executive function. It is the embodiment of the three, taking into consideration the operation and application of the law and submission to it that embodies the rule of law. And within the context of that appreciation of the multifaceted role and component of a rule of law, we need to assess our situation to see to what extent we have made progress in that direction. When you talk of the application of the rule of law with particular reference to the role of the legislature, we were living witnesses to inadequacies associated with the judiciary, for example, as far as its independence and the autonomy is concerned. And within the context of the rule of law, we come to the realization that the better way and manner it can be addressed is through legislative process of constitutional amendment, for that matter, for example. And arising from that understanding, we worked with the legislature to amend the constitution accordingly. That is a function of a rule of law, submitting to a process to achieve what you need to achieve within the context of enhancing the quality of the system. Now, looking at the rule of law as well, we realize delay in administration of justice as equally an issue that needs to be enhanced, addressing the delays. And then we took a decision to bring about certain legislative framework that will eliminate the delay. Administration of criminal justice, for example, to address the criminal justice speedy determination of cases, amendment to Electoral Act to cap a time limit for the conclusion of free election matters, for example. So within that context, the delay in the administration of justice is now addressed to bring it in tune with the rule of law. Again, within the context of the executive, we provided the necessary legislative support as it relates to executive bills that will enhance the quality. For example, realizing the delay or perhaps the congestion in our prison or perhaps correctional centers formation, we came out with Correctional Service Act, which is equally intended to enhance the quality of those serving correctional centers term, among others. So within the context of the executive disposition, I think the executive and indeed the administration of President Muhammadu Buhari has taken a broader look of the administration of justice, has taken the broader look of the context and the content of rule of law to bring about the necessary policies, necessary legislative, legal, administrative, and indeed judicial framework to enhance the quality of the rule of law. Now coming to perhaps the obedience to court order. The simple question that you need to ask yourself as far as the administration of President Muhammadu Buhari is concerned is whether there exists a wholehearted submission to the judicial process as far as enforcement of, as far as obedience or otherwise to the determination of courts are concerned. The simple answer is this. The administration of President Muhammadu Buhari has indeed established a track historical record of submission to judicial determination. Those decisions that the system believes are not in tune and aligned with its spirit or perhaps with the public interest, it equally goes back to court to challenge. And I think the whole essence and spirit of rule of law is submission to established system, either judicial, legislative, or executive, where the component of the organs of the government agrees and indeed submit efficiently and effectively to the rule of law within the context of allowing the process, the procedure, the organs of government to operate optimally and effectively, I think the concept of rule of law is established. Perhaps what we are witnessing today in terms of impunity, in terms of insurgency, could equally be attributed in one way or the other to a religious submission to the rule of law by the government. Consider, for example, the Chapter 4 of the Constitution on enforcement of fundamental human rights. People are now operating much more in breach as far as the fundamental human rights enforcement are concerned, as against perhaps operating in such a way that the fundamental human rights are intended to bring about a harmonious coexistence in the system. How can you imagine a Nigerian taking arms, one Nigerian perhaps killing over 100 people, or only out of the spirit perhaps of consideration for the enforcement of the fundamental human rights? So perhaps what is unfolding today is on account of religious observance of the rule of law as enshrined in the Constitution, perhaps rather than people taking advantage of the human rights principles, taking advantage of the fundamental human rights established in the Constitution positively, they are perhaps pushing it outside the realm of the constitutional consideration. So these are factors that, arising from experience, we equally need to enhance and shape the psyche and mind of Nigerians to operate positively within the context of the fundamental human rights established in the Constitution, and not to be overreaching by way of perhaps creating a situation of a situation that is detrimental to the interest of others. A single individual, within the context of the public interest and the interest of justice, cannot unilaterally take a decision that will now render the judiciary helpless, render the executive and legislature helpless, all in perhaps out of appreciation of expression of, out of perhaps purported consideration of the rule of law. There is no rule of law in perhaps unilateral decision to operate in breach of a constitutional order.
Attorney General of the Federation, just before we go on this short break, I would like you to speak to this point. You have already indicated, yes, that where there are judicial decisions and the executive branch feels that it needs to challenge it, it has gone ahead to challenge it, and then, of course, maintains its obedience to court orders subsequently. Do you get concerned sometimes when there appears to be a conflation of the appropriate authority to deal with a second circumstance? Let's be practical in this instance. From time to time, supporters of El Zakzaki stage protests here in the Federal Capital Territory, calling for the release of their leader, who's been held up since 2015, I believe, and then, of course, the trial is going on. You get worried. Whose jurisdiction is it when there is probably no public understanding of who is supposed to act?
You see, Mr. Kingsley, once a matter is before a court of law, the expectation of the parties is submission to the jurisdiction, determination, and powers of the court. So, and once that matter is being judiciously determined through judicial process, if you have grievances, the better port of call for determination, submission, and consideration of those grievances are judicial process. So when a matter is pending before a court of law, it is out of place for anyone to have recourse to the executive for the purpose of enforcement of rights, privileges, and interest. The proper venue, proper fora, proper place for determination of such grievances, for perhaps getting concessions and understanding is the judiciary when a matter is pending before the court of law. That is what the independence of judiciary is all about. But where you now approach a judiciary for perhaps certain concessions, certain understanding, bails, release, and associated things, judiciary make a pronouncement allowing or perhaps granting those concessions. Within the judicial cycle as well, there are mutual considerable rights within and indeed embedded in this judicial process. What are the rights? If your request, your application or demand for a release of person that is in custody is granted by a first strata of the judiciary, which in this case could be either a state high court or perhaps a federal high court, if the government is dissatisfied, it appeals the decision, files an application for variation. When these processes are ongoing, when the judicial process has not been exhausted to the Supreme Court level, it is out of place to place any accusation of disobedience to an order of the court at the door of the executive. Why? Because the executive in the circumstances has done the needful by way of submitting to the jurisdiction of the judicial system, by way of challenging a decision which has been passed on, by way of taking necessary rule of law process of appealing it and taking it off. So it is the act of not taking the matter before the judicial process for determination, the act of refusing to submit to the powers of the judiciary, and the act of failing to exercise the constitutional and statutory rights vested in you that constitute a breach or perhaps a disobedience to the rule of law. But when the parties are in submission, when within the context of the process they are indeed exercising the rights, obligations, and associated responsibilities legally vested in them, the rule of law as a concept is completed. So that is the essence and context within which we have to appreciate the operation and application of the rule of law.
Okay, Honorable Minister, thank you so much for your response. We'll take a break right now. When we return, we're still discussing 6 years of Buhari administration, judiciary in focus. Don't go away.
All right, you're welcome back. You're still watching Good Morning Nigeria live on NTA's network service. We still have all our guests with us. Chief Festus Oguche, a lawyer, joining us from our Port Harcourt Network Center. Here in Abuja Studios, Professor Akinseye George, learned senior advocate of Nigeria, and of course, the Honorable Minister of Justice and Attorney General of the Federation, Obaka Malami, SAN. One issue that I would like the Honorable Minister of Justice to also refer to. In this case, it has to do with prosecution of certain kinds of offenses. Again, for the benefit of our viewers, the powers of the Attorney General can be located in the Constitution, the Attorney General of the Federation or of a state. He has the powers to initiate, institute, continue, take over, or discontinue any criminal case in this country. But questions have been asked as to why, for instance, there appears to be, even if they are going on, lack of publicity or evidence of the prosecution of terrorists so classified who have been arrested in the Northeast. That's one. Secondly, electoral offenses. After each election cycle, there are all kinds of reports about what goes on in the course of the election. Some of these are said to be federal offenses, even though, of course, murder, of course, will be a state offense. But some of them are said to be federal offenses, and we do not appear to have a lot of prosecution of these matters. Why?
Well, within the context of governance, I think it is important to steward the mandate of the respective ministries, departments, and agencies of government. You have taken time to identify the functions of the Office of the Attorney General within the context of Section 150 and Section 174 of the Constitution. And happily, no mention is made of publicity as one of the functions of the Office of the Attorney General. So what I'm trying to say, what I am trying to say in essence is the function of the Office of the Attorney General, among others, is that of prosecution, in addition to perhaps advising the government on legal matters generally. Now, coming to the act of prosecuting terrorists and associated terrorism cases, for example, it is a function that comprises of multiple agencies and organs of government, of which the Office of the Attorney General and indeed the Judicial and indeed the Executive is a part. But fundamentally and substantially, that function is a function of the judiciary, where indeed those matters are investigated, profiled, and charged to court. Unfortunately, as well, among the statutory functions of the judiciary, publicity is not part of it. So I think that underlies the aspect of the publicity associated with prosecution of terrorist and terrorism cases. But the fact still remains that in our situation, peculiar situation as it is today, we are living witnesses to what COVID-19 has indeed done to the system in terms of slowing the processes. We are equally witnesses to what obtains in terms of security challenges, equally, with particular regard to the polity in general. So if indeed the position hitherto before now was that of simply moving to court, take cases and have them determined through judicial processes, with the prevailing challenges and peculiarities of the terrorist cases that are being determined, extra security arrangement must naturally be factored to mind. And unfortunately, perhaps, when your security outfits are overstretched, it equally affects the speed, it equally affects the arrangement. And as well, when you have when you are out of control in terms of multiplicity of organs participation, it equally poses a challenge. But the story is certainly not gloomy as far as what is being done is concerned. These cases have been determined out of desire to enhance speedy determination of these cases, for example, realizing the limitations and realizing the fact that some of these cases are cases committed at certain localities. For example, at the state level, local government level, we come to terms with the situation that the attorneys general of the state are closer to local governments and state. And we took a collective decision at a meeting with the state attorneys general for the attorney general of the federation to seek for the support of the state attorneys general for the purpose of prosecuting these terrorist and terrorism cases, for the purpose of working together on an understanding. And then the agreement was reached and taken that the attorney general of the federation should now grant fiat to the state attorneys general to partake and participate effectively, monitor investigation, monitor referrals, monitor arraignment prosecution in their localities, taking into consideration the fact that these cases are becoming a kind of very wide in terms of spread and geographical spread. So those fiats were as far back as 2017 granted to the state attorneys general. But I think it is equally important to mention that political factors are equally perhaps mitigating the speed at which these terrorist and terrorism cases are being considered. Perhaps the attorneys general could have some limitations in terms of funding and associated things. But the true position of things is it is something that needs a collaborative and cooperative approach. We may have to revisit perhaps a consensus building in that direction. A consensus building that revolves around the judiciary, the political class, the executive, and indeed the office of the Attorney General for the purpose of enhancing the quality and speed. But the true position of things is we are on a daily basis reviewing our situation and doing the needful in terms of bringing about the desired speed within the context of a legal framework which gave rise perhaps to Administration of Criminal Justice Act, which in effect as well gave rise to a lot of other policy decisions, inclusive of the grant of fiat by the Attorney General of the Federation onto the state. And then perhaps maybe we may require to come together again to see within the context of prevailing challenges that are hampering the speedy determination of these cases what we need to do. What we need to do, what security arrangement we need to put in place. Perhaps if you are to have in place a judicial process in Borno for the purpose of determining the terrorism cases, what security arrangement we require, what buy-in we expect from the judiciary, what support is expected from the executive, what support is expected from the state attorneys general. It is indeed a function that is collaborative, cooperative, and multifaceted in approach. No single unit or organ of the government can do it alone. The office of the executive, the office of the attorney general, however much it desires to bring about speedy determination of these cases, cannot do it alone without the judiciary, which has the function of determination. And judiciary that feels threatened security-wise cannot put the lives of its judicial officials at risk in terms of being in the courtroom to determine these higher profile terrorism cases. And the same thing with the security institutions. Their buy-in is required to provide the desired security so that the lives of judicial officers are not put at risk. And indeed, the attorneys general of the state are equally required to key into it for the purpose of working together with the attorney general of the federation for the purpose of having in place effective and speedy determination of cases. So perhaps we have able course to revisit our strategy, taking into consideration the impediments that are set in it, security challenges, taking into consideration the multiplicity of roles that is necessary to be provided by other institutions for the purpose of prosecution of these terrorism and high-profile cases.
Okay, talking about prosecution and the anti-corruption, we cannot have this conversation without talking about corruption. You have had cause to go beyond the shore of Nigeria to leading a team of Nigerians to go and fight for the right of Nigerians in the UK. The PNID comes to mind. Where are we still on that?
Well, incidentally, only 2 days back, a date was given for us for the final determination of P and the ID, but that date is quite a very long date in 2023. That is the final determination, but then, the final hearing expected in respect of the matter. But then we are looking at the possibility of either bringing the date forward so that at least that matter can now be led to final rest within the lifespan of this administration. But I kept saying over time, the story has been a success story over time. We couldn't have perhaps been celebrating what we are celebrating today in terms of infrastructural development, in terms of the quality, the perhaps provision of democratic dividends, if indeed that decision has been enforced against the Nigerian state, or around $10 billion judgment will certainly set this country back to ages. But the fact that we have succeeded in, 1, arresting the judgment, the enforcement of the judgment, in 2, having our presentation or perhaps our submission relating to corruption, fraud, and incidental issues that gave rise to that judgment, I think is a cause for celebration. At least we have succeeded in establishing a point that we have indeed an effective U-turn as far as the fight against corruption is concerned. We fight corruption locally and internationally. We record successes locally and internationally. We record convictions. We have a local and international record of recoveries of looted assets. We have established a point that locally and internationally we are up to the task in terms of effective confrontation of the fight, according protection to our assets and the fight against corruption locally, internationally, and in all dimensions.
Well, Attorney General of the Federation, thank you very much. But while we are on this, before we bring in Professor Akinsaye George and Festus Oguche to give us their closing thoughts, time always is our press on this program. We know that on the international front, under the Buhari administration, there were a number of mutual legal assistance agreements that were signed. I think Dubai is one of them. You heard others. But there was always an issue, and I think it's subject now to some inquiry by a committee of the legislature. But tell us something so that we have some clarity as to what's going on. The custody and management of recovered assets. At some point on Good Morning Nigeria, we, of course, heard all kinds of voices as to, look, the recovery agency, particularly if it's ICPC, it has custody. If it's EFCC, it has custody. Police has custody. Federal Ministry of Justice has custody. And there seemed to have been no clear overview as to what we had and how it was being utilized. What's the situation now?
Well, the situation is appreciating and realizing these impediments that create a kind of absence of consolidated data relating to recovered assets, relating to assets in custody of agencies. The executive has taken a decision to prepare what is called an executive bill on proceeds of crime, which has in it embedded an agency that is known as Asset Recovery and Management Unit, or perhaps agency. And the intention of that executive bill is to create perhaps a database, a centralized database that will be responsible for profiling the general assets, both in terms of recovered, interim forfeiture, final forfeiture, disposed, what is realized, where it is stored, and how it is being administered or perhaps been disposed. So I think where we are, now we have realized the defect in the system in terms of absence of consolidated data bank as far as the recovered assets are concerned, and we have taken steps to present an executive bill before the National Assembly. Unfortunately, that bill has been pending before the National Assembly as far back as 2017, and we are still hopeful and anxious of having that bill that will bring about the desired transparency, accountability, and coordination in terms of management of assets. But notwithstanding the impediments arising therefrom, we have taken steps to establish a unit in the Federal Ministry of Justice and establish as well a database that is being worked upon, and then pass regulations that will now see to it that necessary consolidation, necessary perhaps strategies are put in place for the purpose of bringing about the desired transparency, the desired information is obtained and available for for immediate access. And that department is wonderfully doing well, and we are building guidelines. In 2019, the Office of the Attorney General came off with guidelines for the purpose of asset recovery and consolidation, and we are doing wonderfully well in that direction. It is a multifaceted ministries, department, and agencies of government inter-ministerial committee that is now put in place and responsible for disposal of assets.
Thank you very much. Professor Akinsaye George, can we get a perceive from you as to what you would like to see going forward?
Briefly, running out of time.
Yes, all I would say is that government has done a lot. There's no doubt about that. The judiciary has also made a lot of contributions. However, we need urgently to address issues of rule of law and order in the land. So that the environment does not stifle out life out of the Constitution and out of democracy. So we need to, strengthen the rule of law. Yes.
Okay, Chief Festus Oguche, in 30 seconds, tell us how you would like the judiciary to move forward in time.
30 seconds is just a very short time, but I would say that, the Attorney General has spoken. There's very much need that the institutions be strengthened, the democratic institutions, which also includes the judiciary and the police, the law enforcement authorities, and you want some reforms as well in the judicial sector. Very serious, vigorous reforms, electoral reforms, all manner of reforms in every sector to give them some fillip to operate. And I very well commend the government for the innovative process it has taken in granting some shade of autonomy, financial autonomy to the judiciary. And I'm still wondering why the Jusun had to go on strike to get the governors of the states to implement provisions of the Constitution. We also look forward to the fact that the government should respect more of the judgments of the courts, specifically the ECOWAS Community Court of Justice. The judgments have not been abided with for quite some time, and I'm wondering, maybe it's a process situation, that we also pray and plead that the Federal Republic of Nigeria should allow its citizens to access the African Court of Human Rights. Other countries are submitting to the jurisdiction through the declaratory reliefs and all that contained in the protocol creating the court. We look very much to that. And we pray also that constitutional provisions be abided with in situations that had to do with the judicial sector, because one little move could get a whole lot of interpretations. And this, we got really time of a removal of Justice Walter Onoren. Thank you very much.
Festus Oguche, a constitutional lawyer, he joined us from our Port Harcourt studio. Thank you so much for your input. And Professor Yemi Akinshe George, Senior Advocate of Nigeria and President of the Center for Social Legal Studies. As always, your input is appreciated. Thank you. Thank you so much. Attorney General of the Federation and Minister of Justice, Abubakar Malamisan, thank you so much for an eye-opening and enlightening conversation this morning. Thank you so much. And that's Good Morning Nigeria for today. We thank you for your time. Do join us tomorrow bright and early for another edition of the program. I am Jumo Yusuf.
Take care of yourself. I'm Kingsley Osadola.